So I call the meeting to order. Can I declare the meeting open to the public? Can I welcome members to the 80th meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members that those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the oral evidence session with Peter Dolan on the sentencing bill and the introductory briefing with officials on the Victims and Witnesses of Crime bill will be recorded by Hansard. So can I seek your agreement to this? Agreed?
Agreed.
Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. So can I ask any members, have they anything to declare in relation to today's business? And if they have, they should do it now or when the particular matter arises. I suppose I'll just say about the APG on access to justice, just as a blanket one. Yep. Okay, any further interests to declare at this stage, or are people content to move on? Okay, agenda item number 1 then is apologies. We have received no apologies. And I think we're all catered for. Sorry, Morris said he would be late. That's the only one. And can I advise members that the committee members, Ciara Ferguson, Connie Egan and Doug Beattie, are attending the meeting virtually and are on the screens. Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 18th of June 2026 are at pages 6 to 13 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of that meeting held on the 18th of June? Members agreed? If so, I will sign. Okay? Okay. There you go. Agenda item number 3 then is matters arising. Can I remind members that at last week's meeting the committee agreed to forward a response from the Commissioner Designate for Victims of Crime along with correspondence from an individual to the Department for response to concerns raised by the individual regarding post-separation economic abuse. So can I seek agreement to also forward the CVOCNI response to the individual for information whilst awaiting the Department's response? Members agreed? Okay. Can I also at this point in the meeting place on record my and our congratulations to Jackie Durkin, who has been just announced has been installed then as the police ombudsman for Northern Ireland, and wish her all the best. We thank her for the work she had done with regards to Ginny and the many times we've communicated with her in this Justice Committee, and wish her all the best for the future. And then can I then take place on record our congratulations then to James Corrigan, who is then acting acting up as the Ginny Chief Executive. Is Chief Executive, isn't Inspector. It? Chief Inspector. Thank you, Clark. And wish him all the best in the future too with regards to both those roles. Would members want us to write to them just to offer our thanks and appreciation, and then obviously wish them all the best for the future? Yeah. Is that okay, members? Okay, thank you for that. Can I ask members if there are any other matters arising from the minutes of last week's meeting? If not, then we will proceed to agenda item number 4, which is the Criminal Justice Sentencing etc. bill and the oral evidence session with Peter Dolan. Can I refer members to page 15 to 20 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Mr Peter Dolan on the sentencing bill, specifically in relation to Part 7, which is the road traffic offences. Can I welcome Peter to the meeting? You're very welcome here, and thank you very much for your attendance. And without further ado then, I'll maybe invite you for an opening statement, if that's okay. Thank you.
Thank you, Chairman. Committee members, I welcome the opportunity to make this submission to the committee, and in particular focusing on Part 7, the road traffic offences, and in particular Clause 41, to do with periods of imprisonment. I respectfully urge the committee and the Minister of Justice to amend the law relating to causing death by dangerous driving so that the maximum sentence available to the courts in Northern Ireland is increased from the current 14 years to at least 20 years, and preferably life imprisonment, bringing Northern Ireland into line with the sentencing framework that currently exists in England and Wales. This is not simply a legislative issue. It concerns public trust in the justice system, consistency across the United Kingdom, recognition of the devastating impact on victims' families, and ensuring that the most serious cases attract sentences that properly reflect the gravity of the offending. Our son, Enda Dolan, was an exceptionally talented and popular young man, academically gifted, an accomplished athlete, and a talented guitarist, basically an all-rounder. Enda, aged 18 and a half years of age, had been studying architecture at Queen's University in Belfast for just over 3 weeks when he was killed by a vehicle while walking on the pavement on the Malone Road on the 15th of October 2014. The vehicle mounted the pavement, hit our son, carried him on the roof of the van for half a mile, where he was then thrown off and left like a bag of rubbish on the side of the road. The driver of the van drove off, subsequently crashed into a lamppost sometime later and had to be cut out of the vehicle. He was caught red-handed. The driver was more than 3.5 times the legal alcohol limit and high under the influence of drugs. He was initially sentenced to 3.5 years imprisonment and 3.5 years in licence. Following a PPS appeal, the sentence was increased to 4.5 years imprisonment and 4.5 years in licence. For our family and many other families in similar circumstances, this did not feel proportionate to the loss suffered, nor did it send a sufficiently strong deterrent message. This, in our opinion, was not justice. Enda lost his life. Our family received a life sentence of grief. The offender received a custodial sentence measured in years. Over the last 10 years, we have engaged extensively with the Department of Justice officials, the former Justice Minister Claire Sugden, the current Minister of Justice Naomi Long, the former Prime Minister Theresa May, various MLAs, key stakeholders, and other bereaved families. Our experience has reinforced the urgent need for reform. The law in England and Wales has already been strengthened to provide significantly higher maximum penalties for the most serious driving offences causing death. Victims' families in Northern Ireland deserve the same level of protection, recognition and justice as those elsewhere in the United Kingdom. Legislative parity is a matter of fairness and consistency. In England and Wales, the Police Crime Sentencing and Courts Act 2022 increased the maximum sentence for causing death by dangerous driving and for causing death by careless driving while under the influence of drink and drugs from 14 years to life. Sentencing guidelines now recognises that the most serious cases may involve deliberate disregard for public safety, prolonged dangerous driving, racing, gross intoxication, or other exceptionally serious aggravating factors. In contrast, Northern Ireland retains a maximum sentence of 14 years, creating an inconsistency across the UK. There is no principled justification for maintaining a lower maximum penalty when the consequence is the loss of human life. The reforms in England and Wales acknowledge that some driving offences are so grave and reckless that courts should have the power to impose life sentences where justified. Northern Ireland should adopt the same approach. A motor vehicle in the hands of a grossly intoxicated, drug-impaired or recklessly dangerous driver becomes a deadly weapon. Where there is an individual knowingly drives while heavily intoxicated or under the influence of drugs and causes death, the outcome is no less catastrophic than the use of any conventional weapon. The law should recognise this reality. Not all dangerous driving cases are the same. There is a clear distinction between momentary error and conduct involving extreme intoxication, drug impairment, persistency disregard for road safety, excessive speed, racing or deliberate risk-taking, previous relevant convictions. In cases involving the highest levels of culpability, courts should have access to the most severe sentencing powers. The current maximum sentence of 14 years, which may be reduced further through mitigating factors, does not adequately reflect circumstances where an offender knowingly drives while grossly impaired and causes death. This needs to change. Many bereaved families struggle to understand how conduct resulting in the loss of innocent life can attract sentences perceived as substantially lower than those imposed for other serious offences. This is not about vengeance, it's about proportionality. The public expects the law to recognise the seriousness of causing death through grossly dangerous and impaired driving. Providing courts with the power to impose sentences of up to 20 years or indeed life imprisonment in the most exceptional cases would strengthen the confidence that the justice system can respond appropriately. While no sentence can restore a lost life, criminal law serves important purposes: punishment, deterrence, public protection, denunciation of unlawful conduct. A stronger sentencing framework would send a clear message that those choosing to drive while heavily intoxicated or under the influence of drugs is among the most serious criminal decisions a person can make. I urge the committee to recommend an amendment to Clause 41 of the Criminal Justice Bill to increase maximum sentence for causing death by dangerous driving and for causing death by careless driving while under the influence of drink or drugs from 14 years to life. Such reform would bring Northern Ireland in line with England and Wales, better recognise the value of victims' lives, strengthen public trust in the justice system, allow courts to deal appropriately with the most serious offending, and ensure sentencing powers reflect modern expectations of justice. Finally, the death of our son Enda exposed the inadequacy of the current sentencing framework for the most serious dangerous driving offences. No legislative change can undo what happened or lessen the lifelong impact on our family. However, the law can ensure that future cases are met with sentencing powers that properly reflect both the gravity of the harm caused and the culpability of those responsible. I therefore respectfully ask the Justice Committee to support amendments to the Criminal Justice Bill so that Northern Ireland adopts a maximum penalty of life imprisonment for the most serious cases of causing death by dangerous driving. Such reform would represent a meaningful step towards justice, consistency and protection for future generations. Finally, I thank the Justice Committee for considering this submission and place on record my appreciation to the Minister and officials within the Department of Justice who have worked with us over many, many years. Thank you.
Thank you very much, Peter. Thank you very much for your presentation and your concise way of delivering it. Can I just say to the people on the screen, those attending on Zoom may only be getting a black screen, and if that is the case, broadcasting are aware and they are working on it currently. So even though you can't see us, I hope you can hear us at the very least, and we'll try and get that resolved for you as quick as we can. So thank you for your patience, Clark.
Just sorry to come in, Chair. I think it might require a reboot of the system. So if members online are okay in the meantime to continue with audio, rather than disrupt the session now, we could maybe do that after this session.
Okay, are you content with that? Yeah, before we move on. Okay, thank you very much, members on the screen. And again, thank you, Peter, for your presentation. And thank you that you and Niamh has come down today to meet with us, because it's going to be a very important session, I believe. So thank you. I know that's not easy. I know the depth of your despair and what you're campaigning for. And can I just, before I move it out to members, can I just say that you're very much in our thoughts and prayers at this time as we go through this bill and we deliberate on it, because I know that process in itself will not be easy. So just want to put that on record. I'll put it out to Emma.
Thanks, Chair, and thanks, Peter, and for coming here today. It's, I suppose, powerful testimony that you've given, and I mean, it reflects the seriousness. We're obviously dealing with a bill, but there are people affected by these decisions, and it kind of puts it into stark reality for you when you hear you talking about Enda and just how young he was, and the lost opportunity that's there in terms of the life that you should have been watching unfold at this stage. So, just like the Chair, thank you very much for coming and sharing your story, and appreciate that. I suppose you've set out a compelling argument for why there needs to be legislative change and why you feel that the sentence needs to be increased. And I don't think that anybody realistically could argue with the rationale that you've presented. I suppose our priority is ensuring that any change that we support as a committee or anything that the Minister does prevents further deaths, and gives people who have the potential to be reckless or to make that decision to drive under the influence of drink or drugs have cause to think again about it. And I wondered what your experience to date with how the perpetrator of your son's death was treated and handled by the justice system made you feel as an affected party in terms of the seriousness or maybe lack of seriousness with the crime that had been committed.
Yeah. Well, I suppose, first of all, after a terrible tragedy, you try and get your thoughts together. You then go through the various different court proceedings, and that is an experience that I wouldn't want anybody to go through. Very, very horrific. We've had various different discussions with various key holders, department officials from the Justice Committee as well, or from the Justice Department in relation to our experience. But the devastating issue would be whenever the sentence is delivered and you're standing outside court, it's done and dusted, and you realise that the guy that was convicted for sentence for basically the death of your child gets away with quite a light sentence. It is it's very hard to describe your thoughts at that stage. It's devastating. You feel justice has not been served. You feel annoyed. You're still grieving. You're going through the grieving process again. You just wonder why and what's wrong with the system. And I suppose that's why I am here, and this is why over the last 10 years that I have been campaigning to get this changed, because it's not going to change or affect me at all. It's too late for that. But hopefully somewhere along the line, and those individuals or those people or those families will not realise that until they're standing outside court. And hopefully they will have felt that justice has come through for them, and they would have got something that they are happy with. And nothing will ever take away from, the gravity of what happens. But if you feel that you've got justice, that softens the blow a wee bit.
Yeah. No, I think what you're saying. I mean, none of us can even attempt to put ourselves in that position or imagine what it feels like. But the legacy that you would leave in if you prevented further deaths this way, and I suppose I would have a concern that at the minute that sort of reckless behaviour on our roads has been normalised somewhat, and we see such an increase in drug and in drug use in particular, but alcohol use as well, that people perhaps don't realise the seriousness and how a poor decision. So the education piece beside it, I think, would be key to try and just reflect the seriousness. But I can understand that what you're proposing here would send a clear message to people that this is not to be taken lightheartedly. So no, I appreciate you coming today, and thanks very much.
Thank you.
Okay, thank you, Emma. Brian?
Thank you, Chair. And Peter, just to thank you for coming in today, and Niamh, and just to say that I am very sorry for your loss of Enda. I remember that happening as a news item, and I remember the shock at the time, and you've explained about your talented young son, and I just express sorrow for the grieving that you always feel for the life that was lost, and for your campaigning now for other families, and the feeling that the sentence of the man convicted did not reflect the seriousness of the crime. I understand from what you said he was 3 times over the alcohol limit and he had drugs in his system. He fled the scene before crashing again, and caused the death of your son. So probably one of the most severe such cases. Now, yet the question I have is, even on appeal, his sentence was 9 years and only half of that served. So at that time, was the maximum sentence 14 years?
That's correct, yeah.
So even in his circumstances on appeal, it was only 9 years, the sentence. Were you given any explanation for that, given that it only, even with, it wasn't given the full capacity of what sentence was available?
Well, again, that's hard to take. And yes, we've been given sort of explanations, but again, I don't understand them. And again, just a layperson, and many families have gone through similar experiences to our own. They don't understand why, if the maximum sentence currently, as we speak today, is 14 years, why 14 years is not used. Now, that is a case, or that is something that the courts need to look at, and that's not for today's discussion. There's various different discounts that are given out for pleading guilty at an early stage, and all sorts of mitigating factors like that. Again, in my personal opinion, I don't believe that should be the case, and that all should be looked at. But again, that is for another day. All I know that the current situation and the proposal in the bill of 20 years, albeit is good, and it's a lot better than 14 years, we need a maximum deterrent, and a maximum sentence of life will hopefully be that deterrent. And the families will then feel that they have some form of justice. It will be then up to the courts to decide, and the judges, as to how they go about delivering that.
Mm-hmm. And have you researched what sentences are typically given in Northern Ireland?
My understanding
death
that
through reckless driving or drink driving.
It's my understanding that at the minute in Northern Ireland, nobody has ever been convicted of 14 years.
Right.
Wow.
And what is 9?
I haven't heard of anybody exceeding 9 years.
Right.
So there's a lot of questions there, and a lot of
It's a question of whether, if it's increased to 20 or increased to life, does that, obviously, and you're right to say about that vehicles driven in an unfit state, is a deadly weapon or a cause of death of innocent people, and there should rightly be a deterrence for that. It's a question of whether increasing the maximum sentence will increase all sentences, or will it only increase the maximum?
It's not necessarily increasing all sentences. It will help the situation, but whenever there are the worst cases scenario, similar to our own, if life was there for the courts to use, then you would like to feel that instead of getting 9 years, you would be getting something higher up, and you would leave that courtroom slightly happier.
And have you had time to look into the situation in England and Wales? And you point out there that since 2022 it's been increased to life sentences. Have you had time to study what sentences?
I haven't, but I know that they have studied this. And again, as I said earlier in my presentation, we have met with Theresa May, who instigated the bill in England and Wales. And they had, at that stage, 14 years, and they changed it to life, which was a big step up, but it was greatly welcomed for people like myself and families that have been campaigning over the years for a change in that.
Mm-hmm. And have other people been supporting you in your campaign?
Absolutely. Yeah. We have a lot of positive feedback. People sometimes don't have the voice, they don't have the energy, they don't have the enthusiasm. I'm not saying that I do, but I'm here, I suppose, and listen, I'm prepared to take it on as far as it goes. I think it's important, and I feel very, very strongly about it.
No, thank you for attending today. Thank you.
Okay, Brian, thank you. Patsy?
Yes, thanks very much, Chair, and Peter and Niamh, thank you very much for coming along here today. And I know I've met you before, but publicly just my sincere sympathies to you both as well for coming through everything, but also an appreciation that you've been able to lift this issue and bring it to be here before us today. If I could ask you just, Peter, now you've mentioned a couple of times throughout it all and articulated a very good case for life, maximum of life, but you mentioned exceptionally serious aggravating factors and you mentioned exceptional cases. You've obviously put a lot of thought into this. Can you expand a wee bit on that for us?
Well, I think whenever an individual is sentenced and is more than, well over the limit in terms of intoxication, high on drink or drugs, also maybe there's multiple deaths in the situation, like that is horrific consequences, horrific situations, and at that stage, that's where I'm talking that life needs to be kicked in at that stage.
Maybe add in there a history of similar driving offences.
Yeah.
That's the sort of territory that you're going into with it there. So, could I just ask your experience, because I want to get a picture of this, because the outcome of a case is one thing, but how a case was dealt with through the PPS, the police, PPS, then the courts, it would have been an awful situation for you to come through. But did you find that it was, at whatever tier, that it was dealt with empathetically, sensitively, and professionally?
It's a difficult question, Patsy. We've had various discussions with the Victims Commissioner, with the Minister, with many officials in the department here, just in relation to our experience. We feel that we didn't have a good experience that was relayed to those individuals. And as far as I know, that there has been situations that have slightly changed, or small points that have made that process a wee bit easier for the families.
Maybe just differentiate between your circumstances with, say, officials. I'm talking about the actual process of which led to the conviction, the process, the criminal investigation, then the referral to the PPS, and then the court case itself. I'm talking about the items that led to the conviction. The other stuff around what discussions are you had with the Minister and officials. I just want to keep the two separate, because I want to hear from you your experience of that process.
Yeah. Again, the experience. I believe at that stage, you're basically you're led.
Right.
You have suffered a terrible tragedy. You're trying to get the grips with what happened. Whenever you go down the legal route and you're going to court, that in itself is a traumatic experience, and you've just after come off a traumatic experience. Now, it might be a year and a half or 2 years down the line, and there's a massive delay. But to try and go through that, to try and understand what is going on is quite difficult for the normal layperson, unless you have a background in law, which I don't have. But it is, I've mentioned the word traumatic a number of times. There's no other easier way of describing it. It's traumatic, it's horrific. It is a nightmare to sit through that. You don't understand a lot of items that are being discussed because it's way over your head. It's hard to come to terms with what happens. Whenever the sentence is read out, you basically need an interpreter to explain to you what just happened, because it is not easy. And the courts, the legal process needs to be looked at. It needs to be brought down to earth for the likes of ourselves and the normal person, the normal lay person, to understand and to get the grips with what's going on.
And I'm sort of trying to take it through the levels of police, and they obviously make a case to PPS, and then of course you end up in court. And I think maybe, Chair, we're getting that message that how the case and the judgment is explained and articulated in court is a significant issue. How did you find what the police investigation, how they liaised with you, how the PPS in fact communicated with you, as I'm sure they would have? How did you find that?
I thought the PPS communication was quite good. The police communication, we had a number of issues. We got them resolved. And I think going forward now, they have changed their format as a result of our situation, which is positive. And I think it's a positive for them to receive the feedback that we give them and to act on it. But again, whenever you come to the other side of that, the decision is read out. It's quite hard to understand what just happened and where you go from there. And it's quite hard to get the grips with what happened and the and the sentence and how lenient it is. It's difficult because you've just lost a family member, a loved one, and that's it. You're at the end of the road. There's nothing else after this. And you've just been told that somebody is getting a minimal or a small sentence, or in your opinion, a small or a minor sentence for what they have just done. It's not acceptable. And it's not acceptable to the families. And that's what the problem is, and that is our feedback from the various families out there. They are saying that this is not acceptable. This needs to change. Why is that happening? Whenever you get into a car and you're high on drugs or highly intoxicated, as I said earlier, you're in charge of a lethal weapon. And the deterrent is not there at the minute, and it should be there. And under no circumstances should you get into that car and drive it, because the consequences are horrific.
So if I could just summarise and take it from you then, the sentencing is one issue, and you've more than amply articulated the case there. How the courts deal with the sentencing and explain it to people who bring cases before them is another. And you've said that the police initially was a bit, could have been improved upon, but they have improved upon it now.
That's my understanding, yeah.
That's okay. Thanks very much indeed. Thanks, Chair.
Morris?
Thank you very much, Chair. Thank you, Peter, for your presentation. My sincere sympathy on your loss and earnest thanks in your campaign. I think unless it happens to your family, you can't realise the gravity of it. 25 years ago, on March the 31st, we lost what was a cousin, more like a niece. Had been best man at their parents' wedding. She lived 30 yards as the crow flies from where I live, known her all my life, killed by a drunk driver. A drunk driver who placed more importance in picking up a drop chip than another life in the road. A drunk driver who, because he was well known in the area, they tried to spirit him away from the scene. A drunk driver who frequented a nearby establishment, and that establishment was very reluctant to supply information to the police. A 23-year-old girl, natural blonde hair, ringlets, the type you see an Irish dancer going and paying money to get. She had them naturally. But an only child. Her parents will never see her married, they will never see her grandchild. And it hurts. Even now it hurts. And unless you have gone through that, I don't think that anybody can actually understand the pain of something like that. So without saying much more, I would give you 100% support in your campaign for a life sentence for drunk driving. And I wish you all the best, and again, I extend my sympathies to you. Thank you, Chair.
Okay, Morris. Connie on the screen.
Thank you, Peter and Niamh, for coming in today, and also Morris. Thank you for sharing your own lived experience as well. Peter, I don't know if I've told you before when we met, but I was actually at Queen's the same time as Enda, and I remember the news coming through the next day and how shocked and absolutely devastated all the students were. But that's nothing compared to what you and your family have had to deal with his loss for these last years. So I want to say thank you for such an amazing campaign you've run, and for getting us to this point where it's in the sentencing bill. You've been absolutely tireless in what you've done, and it's really, really important. So I want to thank you for coming in today and sharing your story. And I know that isn't easy as well. And something that it's in the Justice Bill that I think is important is, for the first time, we're setting out the purpose of sentencing as punishment, protection for the public, deterrence, rehabilitation and reparation. And I want to know your thoughts, but I really don't think that we can achieve that without increasing the sentences, especially for this type of crime. So I would be interested to know your thoughts on that, because I think you'd spoken there about how we need this to be a deterrence to stop other victims and to stop this happening to other families. And I'm also keen to hear what your opinion is, because in the bill currently it is 20 years, but you're obviously advocating for a life sentence. And given what we've heard today, I don't think anybody could disagree with you on that.
I think, thank you, Connie. I think a deterrent, and a major deterrent, is vitally important. I think also to bring Northern Ireland in line with England and Wales is important. The consistency is important. Somebody killed in Northern Ireland or in Belfast through a situation like our own with drink driving is no different than somebody killed in Birmingham or Bolton in England, or indeed Wales. And the question would be then, why is our law not the same as theirs? Why can the individual not get potentially life in Northern Ireland, and why is the case in England and Wales that they are getting life? So I think that getting that changed is important. Justice for the families is also important. They need to feel that they have had justice. And we've mentioned that before, but again, that's another thing. If we have life at our disposal, it's up to judges to use that. And if they use it, that's good. If they don't use it, it's up to them. So at least they have that at their beck and call. And I think that's what we're lacking. And I think we need that.
No, thank you. And I think that's such a good point you're making. How can it seems so unfair for those families that other parts, that you in other regions, that you can have a different sentence. So I just want to say thank you both so much for coming in today and sharing your story, and thank you for your campaign.
Okay.
Okay, thank you, Connie. Aoife?
Yeah, look at, thank you for coming in today. A lot of the questions that I had have already been answered, but I do want to thank you for just really eloquently telling your story, which is just devastating. And look, I know it has been said, I don't think anybody can truly understand what you're going through unless they have lost a child themselves or had some sort of loss, but to lose them in such a way as well, I suppose deepens that hurt. And I think the fact that when you were in court over 10 years ago, that I suppose, I don't know whether it's the culture around the courts that re-traumatisation and lack of understanding that your child has been killed by somebody who's under the influence, who chose, like your son didn't get the choice, but that person chose to get into that car under the influence and had that accident, which is just absolutely devastating. And I'm wondering, just looking back at Enda's case with the benefit of more than 10 years of campaigning and engaging, which you have clearly done a lot of, with the legislative framework, do you believe that the sentencing framework that existed at the time limited the court's ability to fully reflect the gravity of the offence and the level of culpability involved?
Absolutely. You know, as we talked before, in our situation, the individual got a maximum of 9 years, half of it which served in custody, the other half out on licence. That's not fair. You know, you think that should be a lot more than that. And the question was at that stage, well, why didn't they use 14 years? That was the start of our crusade to change the law. And I am hoping now that with what has happened, and certainly the bill, and potentially if the Justice Committee see fit to make an amendment to the bill to make a major deterrent, bring it into parity and have that consistency with England and Wales. And maybe somewhere along the line, people, whenever they leave the court, as I said before, and grieving families will be a wee bit happier that they've been dealt a good hand.
Thank you.
Okay, thank you, Aoife. Nearly done, Peter. Just me to go, if that's okay. You're quite right in what you say with regards to a maximum sentence, and we've seen this right across law, where maximum sentences can be set, and a judge will always use their discretion as to what they then sentence somebody for. And I suppose what I would ask or say to you is that a maximum sentence is that, and then a judge will apply all sorts of mitigations, all sorts of scenarios to come to a considered position. If we did raise the maximum from 14 to 20, as suggested in the bill, or to life, how much of an impact do you think that would have on judgments?
Well, I think slowly but surely the penny is dropping for the courts. They see the devastation and the impact a poor sentence has. You just have to listen to the media, the newspaper reports, the news, and you will see another death on the roads. Now, I'm not saying that it's necessarily by death by dangerous driving, but there's road safety issues, there's speed, there's all sorts of situations taken into account. But if we can reduce the figures of the fatalities on the roads by one, we have done a good job. And I think that we need to be looking at that. And I think that the courts and the judges need to take into account what's at their disposal and use it and put down a marker so that in future that you do not get into the car if you have had alcohol in your system, or you do not drive whenever you're on drugs, and you do not speed, because, as I've said before, the consequences are horrific.
We're dealing with two offences here: the causing death or grievous bodily injury by dangerous driving, and then the causing death or grievous bodily injury by careless driving when under the influence of drink and drugs. And it's quite clear here we're changing from 14 years to 20 years in clause 41. Have you considered any sort of definition of and consequences for the amount of alcohol? So we hear all the time about somebody being 3 times over the limit or just over the limit. Do you think there should be some sort of mitigating circumstances for that type with regards basically the amount of alcohol they've consumed? Or do you think that doesn't matter at all?
I don't think it matters.
Right, okay.
That's the simple answer. You know, I can't expand on that. I think that you shouldn't be doing it. You shouldn't have alcohol in your system. If you're going to drive or if you're out for the night, you plan your way home, you plan your way out, you plan where you're going. That's it.
Yeah. You'll know, obviously you're dealing with, and you're speaking to 41, clause 41, but we have 42, 43 and 44. I don't know how much you've looked into them. I don't know how much they're part of your campaign. And if that's not the case and you're not aware, Peter, that's fine. But 42 brings a clause of a period of imprisonment for certain repeat offences. And I haven't got my head around this completely. By this stage, we're still in the process of scrutinising. But it seems to be that there's a maximum sentence for certain repeat offences, whereby if someone does it again, they then get a maximum life sentence. What's your thoughts on that? Have you looked at this?
I haven't.
Right, okay.
Chair, to be honest, so I couldn't comment as such.
So the actual earlier offences are causing death or grievous bodily injury, or causing death or grievous bodily injury by careless driving when under the influence of drink and drugs. So it's the Article 9 and Article 4, 14 offences. But what this seems to suggest is that, and there's a period of 10 years of a difference between the first offence and the second offence, the repeat offence, maybe I should say. And they're basically saying, I think at this stage, that if you are a repeat offender and you've caused death or grievous bodily harm a second time, then that's when you will get the life sentence. So I know you haven't had a chance to look at it, but I'm just merely making you aware then that that's what clause 42 seems to suggest. Pat, you want to come in on this?
Just one point of clarification on that. I'm not quite sure how this might work, but say, for example, that person was sentenced for life for the first offence, but with good behaviour and everything like that, was let out on licence, say maybe after 15 years, whatever that might be. Presumably, if that person was before the courts again, they would have to serve the bit of the licence as well as any maximum penalty they would receive too. So I'm just trying to distill that down into a bit of clarity around the legal aspect of that. Yep. I don't know, by the way, but if we could maybe just have that clarified too, just how that might work through in the legislation, if in fact there was a maximum offence for first time and followed by a repeat offence.
Yeah, so 42 basically, on those two articles, it seems to suggest that they remove the reference of 20 years for references to imprisonment for life. And I think if we are going to, why I raise this, Peter, is if we are going to amend, or someone amends 42, I think then it has a consequence for 41, then I do think it has a consequence for clause 42.
Absolutely.
Because if we are putting people in prison for imprisonment for life, or 20 years instead of 14, or 7 or 9, then I think we should be looking at this clause 42 with regards to the periods, the period of a qualifying period of when you repeat, and I think we need to look at that. Plus, if we are talking about amendments to change from 20 to life, then I think that will affect 42 also, because it suggests going from a 20-year maximum to reference to imprisonment for life. So, and again, I might not have got this right, but I just think that we may have to pair these two together.
The other thing, Chair, too, is that if you've already been convicted and you've done a certain period of time, for example, life or 15 years or whatever you've done, you shouldn't be allowed to drive again. Your licence should be taken away altogether.
So let me then bring you to 43 and 44, two other clauses in this part, and that talks about disqualification period for certain offences, and they talk about Article 35 of the Road Traffic Offenders Northern Ireland Order in 1996, which is a minimum disqualification for conviction of certain offences. Now, I don't have those certain offences in front of me, but they're suggesting that they changed paragraph 1 applies if you a reference to 12 months, where a reference to 4 years, where a person is convicted of offence. Sorry, I have the offences under Article 9 of the Order, which is causing death or grievous bodily injury, and then 14. So those two offences again, 9 and 14, which is in clause 41, they're basically saying, as I read it, and I could be wrong because I'm still very premature in my thinking here, that they're basically saying that disqualification periods are going to be from 12, instead of 12 months, reference to 4 years of disqualification. And then I think then with regards to disqualification period for certain repeat offences. So again, this is where someone does this again. And let me just remind you, Article 9 and Article 14 are the causing death or grievous bodily harm. They have added Article 15.1, which is driving or attempting to drive while unfit to that, and then another 3 articles to that. But they're basically saying if you're a repeat offender in this, that the disqualification could be 6 years. Or so again, I might not be reading these right, but I wanted as much to raise these things with you because they seem to be all grouped.
Yeah, Chair. I just want to go through my own experience. In our particular case, as we've said before, the guy did 4.5 years in custody. He was banned from driving for 5 years, which commenced the day the sentence was handed out. So after 4.5 years, he was free. 6 months later, he was able to drive officially. Now, that has changed to my knowledge since then because we weren't happy about that, and we were able to get that changed for future reference and for other people. But it needs to be looked at. It all needs to be addressed. The disqualification period, the deterrent, all needs to be pulled together because at the minute it's not working. And there needs to be a major, major slap on the wrist for people who are caught.
So, and again, I'm asking you to think out loud here, Peter. So, there's nothing being qualified here. We are on record, but we're looking at this for the first time, and we are thinking prematurely on it. But would you suggest then that if someone is disqualified for a longer period of time, but they're serving time in prison, that disqualification shouldn't really start until they actually have the means to drive?
That's correct. And I think that is the case currently.
Right,
But
okay.
the time that in our particular case, 10 years ago, it wasn't.
We might get that checked out just to see and explore that, just to see where we lie in that regard. I'll bend your wisdom and judgment on this because of the issue we're talking about. You can see how I'm trying to group these all together and try and ask you questions around this. I understand that you're focused on the one thing. I just think that those 4 clauses are linked. Well, they are linked in the fact that they're all Part 7, the road traffic offences, but I just think that to amend one or tweak one, we may then have to look at the consequences of the other, especially on 41 and 42. 43 and 44 are more to do with disqualification periods, but I think we should be looking at those two to make sure there's fairness in the system here. I think it's atrocious that someone could be serving time in prison for a traffic offence that has caused death or grievous bodily harm, and then as soon as they get out of prison they can basically start driving again. And I think that's something that we should be considering and looking at. Is there anything else you want to add, Peter, before we let you go?
Just again, thanks to the committee and the officials for all their help and support over the years. Thank you.
Thank you very much for your time, and be rest assured this committee is considering and looking at this within this memory and place and our forefront of our minds. So know that. Okay, thank you very much. Thank you.
Sorry, Chair, could I just
Just
confirm then that if the committee wants to write to the department on Patsy's question about serving out the end of a licence period for a repeat offence, and then your question about just to clarify the position when someone's disqualified from driving but gets a long prison term, that it starts consecutive to the prison term and doesn't run concurrently.
Yeah, I just don't know that they're compatible, if you like. The clock starts when the other one ends. Peter thought maybe it did at this stage. I'm not aware of that change, but it would be worth
clarify that.
Yeah.
And then, Chair, just to go back to the broadcasting problems that we're having, I think there are still issues with seeing the screen. So the two options really for dealing with it are that Connie, Ciara and Doug continue either just listen to audio, or else the committee might want to suspend to allow them to reboot the system.
Okay.
And then we'll get the visual.
Are we convinced that if we do reboot that it will work? Or is it right, okay, is it worth taking a chance? Ciara, Connie and Doug, what's your thoughts on this? Do you want us to get a recess for you to go offline to come back on again? Or are you content just having audio? I take any one of you.
I'm content just to stick with audio, Paul.
Okay, thank you, Doug. Anyone else want to comment?
I know that Ciara's having an issue with her device anyway, so she could end up getting kicked out.
If it's okay, I'll go out and then come back in through my phone, if that's okay.
Okay, but you have an issue on your side then?
Yeah.
Right, okay. Connie, what's your views?
I think it would be helpful, Chair. Just I don't know. I just find it easier to follow when I can see the presenters. So I it's not a huge deal. I can still hear them, but I think it would be helpful if that's okay.
Okay, well, I'm prepared now that Connie has said that she would rather prefer that. Doug and Ciara, would you be happy enough if we did go into suspension for 5 minutes or 10 minutes to try and sort this out? You guys go off and then come back on.
Yeah, no, absolutely.
Brilliant. Okay, thank you. Okay, then we'll.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound. Committee Room...
Can the meeting open again? Okay, we'll proceed, members. Can I remind members that the committee had agreed to hear from the Law Society along with the Bar of Northern Ireland. Representatives from the Law Society are available to come to the committee next week. However, representatives from the Bar are not available to attend until after recess. So the Law Society has asked to proceed with this session next week if possible. Are members content with that? I think we do need to get the evidence. So, and then we'll hear from the Bar after summer. Members agree to that?
Yeah.
Yeah.
Which bill is that on?
So that's the sentencing bill? Yeah, yeah. So can I ask members if they are content to proceed with a separate session with the Law Society next week and to schedule a session with the Bar in September? Agreed?
Agreed.
Okay. Agenda item number 5 then is the Victims and Witnesses of Crime Bill. Introductory briefing. The Department of Justice oral evidence session. Can I refer members to pages 21 to 79 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Department of Justice officials on the Victims and Witnesses of Crime Bill. The bill was introduced on the 22nd of June and the second stage debate is scheduled for Tuesday the 30th of June. So can I then inform members that the officials providing evidence today are Julie Wilson, Director, Victim Support Division, Access to Justice Directorate, Emma Crozier, Bill Manager, Head of Victims and Witnesses Branch, Access to Justice Directorate, Christopher McLee, Head of Hate Crime Branch, Community Safety Division and Safety Communities Directorate, Leslie Cowan, Victims and Witnesses Branch, Access to Justice Directorate, and Wendy Murray. Victims and Witness Branch Access to Justice Directorate. You're very, very welcome to the committee as always. And Julie, you're going to kick off, I suppose, with a presentation. So without further ado, thank you.
Thank you very much, and thanks for the opportunity to present to you today on the Victim and Witnesses of Crime Bill. The bill is focused on a small number of very significant measures that we believe will have real and necessary change will affect real and necessary change for victims and witnesses of crime. At its core, the bill reflects the Minister's commitment to a criminal justice system that is more transparent, protective and centred on the needs of victims and witnesses, ensuring that they are supported, represented and safeguarded throughout their journey. We're deeply grateful to victims and witnesses who shared their experiences of the criminal justice system, to victim representatives and to justice partners. Their insights have been instrumental in shaping these proposals. The bill contains 30 clauses across 3 parts with 2 schedules, and with your permission I'll quickly take you through the provisions. Part 1 provides for the establishment and functions of a statutory commissioner, with a schedule then setting out the governance and operational arrangements. This has been informed by extensive scoping work, by other commissioner models and by learning and experience that was shared by the current commissioner designate. The Statutory Commissioner's principal aim will be to promote the interests of victims and witnesses, and the wording in the bill has been drafted to be deliberately broad to allow for flexibility and to enable the Commissioner to respond to evolving changes. The role is intended to be strategic in nature. It is not intended to become involved in individual cases or to intervene in criminal or related proceedings, but rather to strengthen the system as a whole in order to drive improvements for victims and witnesses. The Commissioner will be required to review the operation and effectiveness of the Victim and Witness Charters at least every 3 years and to prepare and publish a report on their review. They will also have a power to issue guidance on best practice relating to the interests of victims and witnesses, and any person exercising public functions should have regard to that guidance. The Commissioner will also be able to establish advisory groups to inform the exercise of their functions. In particular, clauses 16 to 19 require the Commissioner to prepare a strategic plan, an annual business plan and an annual report. They will have scope to set objectives and priorities, and they must specify the groups of victims or witnesses to whom they will have particular regard. And this approach broadly reflects the existing model that's already in place in respect of the Commissioner designate, which we believe has been effective. It seeks to balance independence with accountability and also allows the Commissioner to respond dynamically to changing needs without the need for further legislative change. Clauses 9 to 15 strengthen justice system accountability by requiring the Commissioner to monitor compliance with the Victim Charter. They place requirements on charter service providers in respect of requests for information and responses to recommendations that are made in the annual report. However, we have identified a gap around recommendations that are made in other reports by the Commissioner, and we plan to work with the Office of Legislative Counsel to draft an amendment to fix this oversight. Turning to the hate crime provisions, Judge Marinen's review highlighted serious concerns that victims may be discouraged from giving evidence if special measures were not considered and if defendants chose to exercise a right to cross-examine their victims in person. The bill therefore makes provision for automatic eligibility for special measures in hate crime cases should witnesses wish to avail of them, recognising the fear and distress often involved. It also prohibits anyone charged with offences under the new statutory aggravation model, which is included in the sentencing bill. So it prohibits them from personally cross-examining the victim of a hate crime. So these measures aim to give victims and witnesses greater confidence and protection when engaging with the criminal justice system. Turning then to protection of complainants in sexual offence cases, Clause 26 contains measures that are intended to protect complainants in serious sexual offence cases and to improve their confidence in and experience of the criminal justice system. Evidence from the Gillen review showed that many complainants felt exposed and disadvantaged during proceedings. They spoke of a perceived imbalance because the defendant alone had a solicitor and a barrister to advise them, and because the complainant also faces the prospect of having their sensitive personal information shared with the court. So in response, the bill allows complainants in serious sexual offence cases to make oral or written representations, to be legally represented, and to attend hearings concerning applications to disclose their sensitive personal material, and then similar protections apply to applications involving previous sexual history. New court rules will also specify when a notice of the pre-trial application must be served and the manner in which it must be served, as well as how sensitive or confidential information is to be treated. This will ensure that the complainant receives timely notification so that they can seek independent legal advice on their rights. These measures are based on the existing non-statutory judicial practice direction. They provide for greater regulation of the disclosure process, balancing the rights to privacy with rights to a fair trial while strengthening confidence in the system. Finally, the bill also includes a legal technical fix to future-proof the no-bill procedure in light of consequential changes as a result of direct committal. The specific measure in the Victims and Witnesses of Crime Bill is needed because when direct committal is implemented, the wording of a no-bill application will change to an application to dismiss. So this technical provision is effectively to rename that application to ensure that the process is future-proofed. In terms of financial impact, the costs have been carefully considered, and the Department of Finance has confirmed that it is content with the proposals, noting that the establishment of the Office of the Statutory Commissioner will be subject to an approved business case and affordability considerations. So we're currently working with our finance team to finalise that business case. In relation to legal representation for complainants in serious sexual offence cases, our intention is that in all but the most exceptional cases, this will be provided by extending the role of the Sexual Offences Legal Advisor Scheme, which DOJ funds, and our assessment is that minimal additional resource will be required. I hope that this overview has been helpful, and we're happy to assist with your questions. Thank you for your time.
Thank you, Julie, for that presentation, and very succinct as it was and concise. Brian?
Thank you, Chair. Thank you for the presentation. The Commissioner designate, how long have they been in post?
I'm going to turn to Leslie, who will have the detail on that.
Yeah, they came into post in 2022.
Right. Okay, so that's 4 years now or so?
Yeah.
Okay. So I'm interested in Clause 8, the practical outworking of that. You explained that the Commissioner may not exercise any function in relation to an individual case. So I'm sure many people who are, particularly if they're dissatisfied with the outcome of a case, no doubt will approach the Commissioner. And when the Commissioner is identifying an issue, affecting victims and witnesses, that will be exemplified by individual cases. So there will be time that they will want to obviously examine individual cases and see what can be learnt and see how do they get the balance of, they're not an appeal mechanism, but they will want to examine individual cases and draw lessons from them.
Exactly, and there's nothing in the bill to prevent that, and that is the current situation as well with the Commissioner Designate, who has that ability. What we want is for the Commissioner role to be at a strategic level, identifying strategic issues and driving improvements on those, but recognising that actually the exemplars of those will be in individual cases. So it's not supposed to be an advocacy role, but that doesn't prevent the Commissioner from learning from individual cases. Emma, do you want to say anything else?
Yeah, so the role, I suppose, is to have a system-wide oversight of the issues affecting victims. So the Commissioner will be encouraged to, one of the clauses encourages the Commissioner to meet with victims and to get their views, so they won't be stopped from doing that. The clause is really to prevent them from getting involved in the outcomes of cases or investigations, or as you say, it's not an appeal mechanism or a complaints body, but they can still engage with victims to get a sense of what those issues are and if there are any trends impacting victims, and then they can bring that forward and shine a light on that, if that makes sense.
Right, aye. And yeah, so I hope there'd be like a willingness to at least engage with people, rather than just saying, sorry, you'll have to go somewhere else. I just think it's important that people don't feel they're just being rebuffed, that it can be explained, yes, we're not getting involved as like in an appeal type mechanism, but the Commissioner or staff will listen to people's concerns.
Definitely, and clause 3 actually contains a duty for the Commissioner to encourage victims to engage and communicate with them, and to be involved in giving views on how those functions are exercised. So
Yeah, no, I see that 4B.
Yeah.
Okay, thank you. Thank you, Chair.
Okay, Brian. Emma.
Thanks very much, Chair, and thanks to you all for coming in. I just had a couple of points of clarification that I want, and I think probably should say at this point and put it on the record. Obviously, as a member of the Justice Committee, the Commissioner designate who's in post, and I would say that the view there is probably unanimous, in that she's doing a really good role and is definitely putting the voices of victims forward. And I've found on a personal basis, like somebody that's really easy to work with, and obviously presented to the committee and was really powerful in doing so, in representing the views and voices of victims. I just wanted to ask around basically her power. So she must advise a department or executive committee of the Assembly on matters concerning the interests of victims and witnesses as soon as reasonably practicable after receipt of request for advice on such other occasions as the Commissioner thinks appropriate. So I'm assuming from that, and correct me if I'm misinterpreting this, if she or if the person, when the role is statutory, identifies an issue, it doesn't take that it has to always be initiated by a victim or a group of victims. The Commissioner has the power to... Yeah, okay. So they can do that off their own steam if they think that there's...
Yeah, they can. They have powers there around commissioning research and kind of drawing on evidence basis. So obviously we'll want to be informed by lived experience as well. But I think there are a number of ways in which the Commissioner would identify issues, including there's clause in there about having oversight of kind of what the complaints that are coming into criminal justice agencies are. So that's another route of kind of identifying trends and identifying issues. I don't know whether you want to say anything else?
Yeah, sure. Yes, you're correct. The Commissioner, it works both ways in relation to that government advice. So a government department could request advice, or the Commissioner could decide to give that advice. But there's a few clauses which kind of work together to make sure that the Commissioner has the powers that they need. So there's that one we've mentioned. There's also can give advice to anybody, and that really is more factual, explanatory type advice rather than the government advice. And then there's another one, and that's about making recommendations and representations. So that's about more about influence and being able to make those recommendations. They're not binding, but we think they'll carry weight as a statutory office holder. So they're the kind of three powers that work together.
And they don't have to have like an evidence base of where particular victims have brought an issue to their attention. If they can initiate that themselves.
Yeah, they're totally independent to identify issues, trends that they want to shine a spotlight on and bring forward, either as advice or in terms of guidance. They can do that. Yeah.
And I suppose then, just as you've pointed to the independence, what measures will be in place to ensure that they're sort of independent from the department?
So the Commissioner will be appointed by the department and the Minister, and they will then become like an arm's length body of the department, but they will be completely independent in the exercise of their functions, so the department won't be involved in interfering or influencing reports or recommendations or anything like that. So the Commissioner is free to scrutinise and challenge and criticise the department if necessary. So there's that appointment and, I suppose, governance and accountability, but the separation that the Commissioner and their office are independent.
Okay, thank you.
I think broadly mirroring what's in place in respect of other commissioners as well. I think we've looked at how other commissioners do this, and that's helped to inform this. So it's fairly standard.
Yeah.
Thank you.
Okay, thank you, Emma. No other member has notified to ask questions, so leads me then to ask questions, Julie, on this. So you've already mentioned here that you've given the intention here that you may move possible amendments around the removal of Commissioner, suspension of Commissioner, responding to recommendations from the Commissioner. And then there's one about sharing personal data in urgent or emergency situations. Can I ask the first two, removal and suspension of the Commissioner, is that something that you always intended to do, but you just needed to get the bill out the door and into process, or is this something that's came to light over the last, say, since the bill's been written?
I think the suspension of that's in response to some thinking that TEO is doing around wider commissioners, and it's to align with that. Mm-hmm. So I think that's come to light subsequently.
Exactly, yeah. We knew that work was ongoing with TEO for the other commissioners, so we were reluctant to put anything in the bill that would then be at odds with what comes through as a result of that work. So we thought better to wait to amend the amending stage so that we can be in line with other commissioners on the suspension.
So on that, with the range of commissioners we would have in place in situ here in Northern Ireland, is TEO is going to lead on that work with regards to a generalisation of trying to get that into sync, or are you just doing this because you don't want to be behind the scene whenever you're just launching this bill? And is there any other commissioners or posts within the justice purview that needs to be considered at this stage? And if there is a yes to that, is there a possibility that could be also included in this bill too, or would that be out of scope?
I think in terms of other commissioners, I'm going to put myself at risk here. I'm not aware of other
there might not be
justice commissioners, and I think that this is specifically on commissioners. So, but we can come back and we can clarify that for you. And then I think
it might be that TEO is going to do it for the whole purview of every department. I don't know if they have the virus to do that, or whether that be a big all-embracing cross-departmental bill that's required for that. I just don't know, but I just picked up on it because it just seems obvious now that we would have powers of removal and suspension.
And I think the removal one, that's for us to clarify whether there's already, whether the catch-all already exists and whether the provision is necessary. So there obviously needs to be a power, and I think we're just trying to clarify whether there is already an existing power that we can rely on.
No, that's right. We in Schedule 1 we have a list of instances where the commissioner could be removed, but we wanted to do a bit more thinking on whether a catch-all is needed or whether that's too broad, and what we've already got suffices. So it was a bit more thinking on that.
And then with regards to sharing the data, your conversations with ICO, how are they coming on? Are they advanced stage? Do we have an answer yet as to how comfortable we are?
Yeah, so they've been very helpful. They've come back with some correspondence in the past week or so. So we are now going to go back to them and ask them about this potential amendment. So I suppose the policy position hasn't changed. We still want the commissioner, if she has somebody who comes to her and they have a particular concern about them, that the commissioner would be able to make a referral, or but what we want to check with ICO is that obviously there's the GDPR and DPA that already provides for that. So we just don't want to put anything in the bill that may cut across that and then actually limit what we're trying to do here. So we think we are just seeking their advice. So it's a potential amendment, but at the minute we're thinking that what's already in GDPR and DPA will suffice. So.
Okay, thank you. Can I take you then on to Brian? You want to come in on that issue there?
No,
or
it's
a different issue. I'll bring you in at the end. Can I ask you then about part 2, the criminal evidence and procedure? And we all understand how we've come to here and why we've come to here and the long processes and consultations and reports that we've had. But how, I suppose, can you assure this committee that the balance is maintained and the scales are not tipped one way or the other with regards to protecting victims and then also the rights of the defendant?
At a high level, I think what this bill does is it enhances protections that are already there. So, and it doesn't seek to remove rights from the defendant. It's about enhancing the protection rights. Emma or Wendy, do you want to say a bit more about that?
Yeah, just to say that first of all, the new process, disclosure process, won't change the stages at the investigatory stage, the police investigation stage, or the prosecution whenever they're doing the disclosure management document. So anything that points either towards the defendant or away from the defendant will be still shared in that document. The defence are still able to make disclosure applications depending on what third-party material they think is available that could support their case. All applications then will be overseen by a judge. So the process will work where the complainant will be given, they'll be notified of the application being made. They'll be given the opportunity to make oral representations to the court. If they do not wish to make representations, the judge will consider the application on the papers. If the complainant does wish to make oral representations to the court, then they'll be hearing listed, pre-trial hearing listed before a judge, and they'll consider and balance the Article 6 and Article 8 rights of both the complainant and the defendant. And that it's a judicial oversight that will make sure their rights are balanced, it won't swing and tip the balance in favour of one or the other.
What safeguards are in place to ensure that all exculpatory evidence is actually disclosed?
Yeah.
Even if it's not requested
yes.
from the defence for one reason or another,
yeah.
And that could change everything. How are we assured that that's still going to happen?
That'll be the judicial oversight again. And again, everything that's to the investigatory stage, the prosecution will assess that material and share that in a disclosure management document with the defence. If the defence find within that there's something that they think there's something missing, maybe the complainant has given a list of their GP records or GPs have attended or counselling records, but maybe there's something that they've missed. The defence is still able to make an application to the court for that. It's not to say that something, I can't hand on heart say that every single scrap of evidence will ever be found, but the defence, if it's there, the judge will oversee and make sure that they think everything is there that needs to be, that if there is exculpatory evidence there, even though it's not requested by the defence specifically. If the judge thinks that there's maybe something missing, they will make an order for it to be disclosed.
Okay. I know we can say this by every law we create, but how can we ensure then it's going to be consistently applied across, the new disclosure processes are going to be consistently applied across the court settings?
Again, it will be for judges to manage that. I mean, in terms of the processes, as Wendy said, the disclosure management document will always be made available. So there's a safeguard there. This is about allowing complainants to have notice of the applications are being made, so that they can have their interests represented. It will ultimately, it will come down to a judge who will be using their judicial discretion and their judicial independence to assess what's before them. And so,
is there any sort of review mechanism that the department's minded to put in to at least have a view of it in 3, 5, 10 years?
At this point, no, although we're open to looking at that. I think we would want to also engage with the Lady Chief Justice's Office and Judiciary as to how that could be done, just to inform our thinking on it, but we would definitely be open to it.
Can I bring you on to the space in hostility? And I get the whole hostility piece, the aggravation by hostility, the fact that we don't really want someone to be cross-examined by, the person who could well have been hostile towards them. Mm-hmm. So I get that, and I see the direction of travel we're going. There's no issue there. But what defines hostility? I suppose is the first question. If the test is currently only about perception.
I'm going to turn to Chris on this one.
Hostility, it's sort of, it's a well-known, or it's a well-understood phrase amongst our policing and PPS colleagues. So they'll only bring that case within the sentencing, etc. bill. So an offence aggravated by hostility is defined within that bill.
Mm-hmm. We've got one ready here, and so it's defined in the sentencing bill, which then will relate to this part 2 of this bill.
If you like, they're accompanying pieces of legislation.
Right. Okay. Well, that's really interesting, and I think because I wasn't actually aware of that, even though I've read the sentencing bill, but I thought maybe hostility was a longer piece of work.
So the aggravation by hostility within the sentencing bill, and then this special measures for charges brought under that.
So you're very clear that the hostility definition comes from the sentencing bill and no earlier period. Right. Okay. That's very, very interesting. So then, will it be perception then?
I think hostility is, trying to think back to the sentence bill now. It's motivated or demonstrated by hostility towards your race, sexuality, disability or religion.
Will it be purely then down to the victim?
I need to just go back and check on that.
Yeah, sure. No, that's fine.
Come back to you on that.
That's fine. And if it is purely down to the victim, serious as it may be, and serious, obviously, we believe the victims may not know all the details of a certain case or an investigation. There might have been multiple victims that day by the perpetrator, and it may not be down to hate crime or hostility, if you know what I mean. Yes. So that's where I worry around this, and then not creating a 2-tier system.
Yeah. Well, I suppose in terms of a 2-tier system, what we're proposing here isn't anything new or unusual. It's maybe identifying hate crime victims as vulnerable victims in line with the likes of domestic abuse and things like that.
Yes.
So the application will have to be made. Sorry, to rewind. So what we're saying is hate crime victims are eligible for special measures, but it's still up to the judge to decide whether they get them, what the measures might be.
Okay. Okay, I'll maybe read up a wee bit more about this. That'll be my weekend reading because of the second reading on Tuesday. Brian?
Could I just come in? That's what I was going to ask the Chair. So, Christopher, you've answered my question and Paul's question. How do you define the hostility? So I see it says there, in accordance with section 33(1) of the Criminal Justice Sentencing, etc. Act 2027. Very confident that it's going to pass. So it's a bit strange. It's referring to something which hasn't been enacted, but still it's there at 24(2) in the Victims and Crimes Bill. So my only question though is, because we've had this debate many times about the definition of hostility. So at 33 in the sentencing at 33(1) talks about racial, religious, sexual orientation and disability. We've had debates about vulnerabilities which is at 36, so that's not referenced.
No.
And then we've had the debate about the vagueness of what counts as vulnerability. Counts about either under 18 or old age, and significant impairment through physical or mental disability or illness. So it's, I'll look. Have you a view on that actually the wording there doesn't capture vulnerabilities?
Yeah. No. This there are special measures that we've in this bill that is just the hostility aggravator that refers to, not the vulnerability. And
it doesn't, for example, then it doesn't include sex, and it doesn't include sectarianism.
No, just the particular characteristics in the sentence of bill. So your race, religion, disability, sexuality.
Right. But the original bill obviously includes, the reference to sexual offence. So the 1999 order means that somebody charged with a sexual offence can't cross-examine their accuser.
Yeah.
That was the original.
Yes, I think it was original, and then since then I think there's a few more charges have been added to that. So we're sort of adding to the list. So if someone charged with a crime aggravated by hostility won't be able to.
Okay, but current wording won't include vulnerabilities then as it stands. Yeah. Okay.
No plans to.
Right. Okay. Thank you.
Okay. Thank you, Brian. I think that's all. The other members have indicated they want to ask a question, so thank you very much for that. It's very, very useful. And again, I suppose we wish this bill all the best on its journey through the various stages, including the committee stage when it gets there. So thank you very much for your time. Thank you. Okay, members, moving on then. Can I seek members' agreement then to request the delegated powers memorandum for the bill from the department? Members content with that? Yep. Can I ask members then if they're content that the committee staff forward the delegated powers memorandum to the examiner of statutory rules in the committee's absence if required over the summer recess period? Yep. Agreed. Okay, can I advise members then the proposals for the call for evidence on this bill will be considered at next week's meeting? Okay. Agenda item number 6, Finance Update, Department of Justice Oral Evidence. Can I refer members to page 80 and to 111 of the meeting pack for the relevant papers? Can I inform members that today Department of Justice officials will provide the committee with an update on a number of financial matters, including the provisional outturn, the draft budget 2026-27, contingency planning envelope, and updated pressures for 26-27. The officials providing evidence today are Richard Logan, Finance Director, Michelle McLaughlin, Head of Financial Strategy, and Louise Blair, Head of Financial Support. You're very welcome to the committee as always, and I'm sure, Richard, you're going to kick off with a presentation. Thank you.
Good afternoon, and thank you for the opportunity to update the committee on finance-related matters for the department. We've already shared detailed written briefing with the committee in the areas we'll cover today. I therefore intend providing just a brief overview at this stage to highlight some of the key points. Firstly, if we consider the department's provisional outturn for 25-26 that was submitted to the Department of Finance on the 14th of May, this provisional position will be revised in due course to reflect the department's final outturn once the 25-26 accounts have been audited. At this stage, though, I'm not expecting any significant changes to the figures. The non-ring-fence resource DEL element of this underspend was 2.1 million, which, given a budget of more than 1.4 billion, means that we essentially spent 99.86% of the funding available. As in previous years, the department included headroom in the estimates for annually managed expenditure to manage the risks and uncertainties associated with its £1 billion of provisions and £7 billion of pension scheme liabilities. However, as noted in the written briefing, any underspend within AME is non-cash and should not be viewed as a loss of available resource budget or funding being returned by the department. In relation to the 25-26 statutory accounts, The Department submitted its draft annual report and accounts to the Northern Ireland Audit Office on the 29th of May in line with the agreed timetable. At this morning's Departmental Audit and Risk Committee, the Audit Office advised that whilst their work is still to be finalised, it is proposed that the Controller and Auditor General will certify the 25-26 financial statements with an unqualified audit opinion. In other words, this is a clean audit opinion, which is the outcome we wanted to achieve. We are currently on course to meet the summer recess deadline of the 3rd of July for laying the accounts in the Assembly, and that will be a significant achievement in terms of the Department fulfilling its statutory reporting duties and ensuring compliance with governance and accountability responsibilities. With regards to the latest budget position, the Committee will be well aware that there has been no agreement as yet by the Executive in terms of a final budget for 26-27 and future years. We are still therefore using the financial information contained in the proposed draft budget from the Finance Minister as the basis for planning and budgeting across the Department. It also means that there is no June monitoring round, which we would normally have been updating the Committee on at this time of the year. In the absence of an agreed executive budget, the Department of Finance has put in place interim measures in the form of a contingency planning envelope and accompanying guidance. Guidance provided by DOF highlights that the CPEs will be overwritten by any budget subsequently agreed by the Executive, but in the meantime, the CPEs will provide accounting officers with parameters to inform their assessment of affordability in the absence of an agreed budget. CPEs provide a reasonable working assumption of the minimum any department could anticipate receiving through a subsequent budget process. However, this funding is not guaranteed, as the Executive could make different decisions in agreeing its budget. As noted in the written briefing, the CPE for DOJ falls well short of the funding required to deliver the Department's current spending plans for both resource and capital. For the purposes of planning, and after taking into consideration the risks involved and the advice in the DOF guidance, the DOJ Accounting Officer's assessment is that there is a reasonable expectation that the Department will receive no less than the funding outlined in the proposed draft budget. This assessment takes into account the fact that the sum total of CPEs across all departments is less than the total amount available to the Executive for 26-27 as described in the proposed draft budget. This approach, though, is not intended to prejudge any eventual Executive decision on the proposed draft budget. Updated indicative draft budget allocation letters were issued to DOJ business areas on the 17th of June on this basis. The resource allocations were effectively the same as the amounts included in the allocation letters previously issued by the Department in February, whilst the capital allocations were revised as detailed in the written briefing provided to the Committee. Since the last time we were with the Committee in February, DOJ business areas have completed an exercise to update their forecasts for day-to-day stabilisation pressures. As such, the revised pressures have increased slightly and are currently estimated to be 103 million in 26-27, 155 million in 27-28 and 242 million in 28-29. And to put the scale of these figures into perspective, the 242 million pressure in 28-29 equates to the total budget for prison service, courts and tribunal service and probation board. The 103 million pressure in 26-27 currently excludes any additional costs for the Department following the public disorder in June. Whilst PSNI received the welcome news just last week of an additional allocation of 4 million from the UK Government towards their costs, we are also aware of significant costs within compensation services for criminal damage payments. Further details of the costs involved will be available once initial assessments have been completed, but by way of comparison, the costs associated with the disorder in 2025 were 5 million for PSNI and approximately 4 million for compensation services. After considering all the options available to live within budget, the overall assessment is that it is not possible to live within the proposed draft budget without implementing significant headcount reductions across the justice sector. The levels of headcount reductions required far exceed those that could be achieved by natural attrition, and there is no vehicle in terms of staff exit schemes or funding to undertake such reductions. Such reductions would also undermine the strategic approach adopted by PSNI and DOJ to increase police officer and staff numbers as part of the policing workforce recovery plan. Ministers confirmed that if the potential reductions in headcount were implemented, the impact on service delivery and public safety would be catastrophic. Therefore, the Department does not consider such reductions in staffing levels as being feasible options that would be implemented. Given the level of pressures, DOJ business areas will still need to take appropriate action to reduce spend where possible, and any new areas of spend should not be commenced without specific approval from the department. Any decisions in relation to stopping existing work streams or services will need to consider the impact of such actions on other parts of the justice system. The department has always and will continue to take proactive measures to live within its budget. However, on the basis that significant headcount reductions are not implemented across the justice sector, the indicative allocations in the proposed draft budget mean that it is now considered inevitable the department would overspend its proposed resource budget in each of the years 26 to 27 to 28-29 in the absence of additional funding being provided. The capital position for the department remains equally stark, with an average shortfall of 150 million in each of the next 4 years against our total requirement. Whilst the department has had relatively low capital requirements in the past, significant additional funding is now vital to fund the capital investments needed to transform operating models, enhance digital solutions and modernise the facilities in which the services are delivered. The proposed capital allocations for the department will regrettably lead to significant delays in implementing planned major projects and also curtail the department's ability to proceed with routine minor works and maintenance. Given the magnitude of the pressures facing the department, transformation remains a key priority to ensure we can continue to deliver our demand-led services in the most efficient, effective and sustainable way possible. The funding already secured in the Public Sector Transformation Fund is a positive step and will help the department's efforts to speed up justice. However, significant additional investment is still needed to transform our operating models, enhance digital solutions and modernise the facilities in which the services are delivered. And it's important to emphasise the link between stabilisation and transformation. In particular, meaningful transformation cannot be delivered from a position of acute financial instability. Stabilisation funding is therefore a necessary precondition of reform. The department's bids in relation to ending violence against women and girls and the PSNI Relativity platform, which will allow PSNI to invest in its digital capabilities, have been recommended for funding by the Transformation Board. However, there is currently no scope to fund these from in the remaining balance of the Transformation Fund of 235 million from HM Treasury. Instead, these projects are reliant on the additional funding to deliver transformation that has been proposed in the draft budget by the Finance Minister. Therefore, final decisions will be subject to agreement by the Executive on the overall funding envelope available to the Transformation Board. One other area to make the committee aware of is the Integrate programme led by the Department of Finance. This is a major transformation initiative across the whole NICS, which will deliver an integrated finance and HR solution to replace the services and systems currently delivered by Account NI and HR Connect. The programme presents a unique opportunity to modernise and improve how all departments manage essential business functions. Implementation will be delivered in 5 waves during 27-28, with finance functions moving between April and August 2027 and HR starting to move from October 27 onwards. The finance functions for DOJ are scheduled to go live on the 27th of June 2027 as part of the second wave. The preparations for implementation are already well underway, but this will be a resource-intensive transition that will increase the workload significantly for finance staff. And we will continue to keep the committee updated as the work progresses over the next 12 to 18 months. In closing, I trust that I provided you with a candid but helpful overview of where we are now in terms of our financial position. The level of pressures remaining will be extremely challenging, if not impossible to manage. It is now considered inevitable that the department would overspend its resource budget in each of the next 3 years in the absence of additional funding. Extremely difficult decisions on prioritisation and service provision will be required to minimise the remaining pressures. This will inevitably involve consideration of issues such as the level of services that can be delivered, staff numbers, pay awards and deferring major capital plans. Engagement will continue with ministers and officials to advocate for additional funding to ensure that we have a justice sector that is funded appropriately now and in future years, which is currently not the case. I'd like to thank the opportunity for to provide the briefing today. We very much value the role and views of the committee. I'm very happy to take any questions.
Okay, thank you very much, Richard, for that. I'm going to put it out to members. Brian?
Just to ask again about the AME underspend, which is substantial, 46%. I mean, I see what you have there at paragraph 10 in the departmental report. Reflects reduced provisions for exceptional legal costs. and headroom included to manage uncertainty in compensation awards. Can you explain more what that covers and why? Obviously, if it wasn't needed, that's hopefully a good thing if the money was able to be used somewhere else rather than returned to Treasury.
So, as a department, we have significant provisions, and particularly in legal claims. So you'll be familiar with the PSNI data breach, holiday pay, and McLeod claims for three of the major ones, and we also have compensation services with the criminal damage and claims like that. Whenever we are preparing figures for the estimates, we'll take into account figures that are in business cases, and there are a range of options. So ideally, a case will settle as low as possible, but we have to provide and take into account and manage the risk of if it comes out much higher. So whenever we have claims, if they're accepted by the claimants, that's great at a cost. If that's turned down and they come back and there's an additional requirement, or if there's a court ruling which exceeds our lower limit, then we would have to pay that. So in terms of being prudent, we build in the headroom to allow us to make those decisions that it's not the estimates driving our actions. So we've got headroom in the estimates that we don't have an excess vote, and we put through whatever that final figure is. So I'd say probably overly cautious in terms of the AME headroom, but my view is I would rather be doing that because it gives us the cover. The alternative is if we cut it, I could have taken 250 million off and I would have been sitting around the table explaining an excess vote. So it's to give maximum flexibility to the department, but it doesn't create a target that either we work to or that we would want the claimants to work to, but it's just to say there are a significant range. Similarly with police pensions, it's a 7 billion liability. So if there was a 1% change in that, that's £70 million. So all it takes is an assumption to change for either life expectancy or a discount rate which Treasury will set of 2 or 3%, and all of a sudden we have a £200 million swing. So it's being prudent and overly cautious, but it's not money out the door. So, but also very mindful of we're not just putting in a figure, thinking of it, doubling it, and adding a bit more. There's a logic to what we're actually doing to be able to back it up.
Was it in the department's budget at the start of the year? I mean, where is this money? Is it just you're going to tell me it's just a notional figure? It's not real money, but what happened to that £250 million?
It just shows as an underspend. So there's no money handed back.
It wasn't allocated as such.
No. So the say that the money that was allocated.
Was it allocated? Sorry to interrupt. Yeah. Was it allocated though from the block grant as such?
Not the cash grant that comes through. No.
Right.
So it comes through. So the executive pre-Christmas agreed that there'd be £119 million of funding for the data breach set aside. Mm-hmm. So in previous years we would have put in an AME provision for that. That will be a DEL, departmental expenditure limit, this year if it's paid, and how much that will be paid. If we were to have increased, and there were various ranges of what the liability for the data breach would have been, but say it had gone up to 150 million, we would have had 30 million AME cover to increase it to 150 million. But we didn't get any cash for it, we didn't pay it out, and we're not returning anything. So it's precautionary to say, and it's more probably from a financial accounting point of view of saying like, we have a liability as a department, but until we pay it out, it doesn't come off the block grant that we're familiar with in terms of the underspends or the pressures. The 100 million that I've quoted is against this current year is against the block grant. The AME doesn't score against that.
The other question I want to ask, Chair, I mean, we hear from various departments about difficulties for volunteering community sector groups who receive funding from departments in the current absence of a budget. So are there groups that the department funds either directly or through arm's length bodies who are maybe, well, they might have had a contract initially for 3 months, which is ending within a week. Are there groups like that under the remit of DOJ?
Or limited, there's a number. I would say between PCSPs and voluntary community groups, it's about 10 million or below 10 million. The department would invest or spend in that. My sense is that we wouldn't be cutting those, and we would in the first instance, we would try to maintain the level we got in 25-26. If there are certain circumstances of particular grants or work and services that are being done on behalf of the department that necessitate a small increase, we would try and facilitate that. But we're not. There's no overall decision that was taken to cut any of those, because we're very, very aware that those sectors face the same pressures in terms of inflation and pay costs that we centrally do. So that's the approach that it should be at least to maintain what was done previously.
Would it have been those that received funding contracts? Would it have been? Are you aware? Was it just for 3 months initially, or was it?
I think in terms of PCSPs, I think there was an informal emails maybe sent in the last day or so just to confirm the approach that was going to be taken, and then formal allocation letters will issue out. We as a department didn't. Back in February, we issued out an indicative budget for the full 12 months. So I think maybe some departments might have restricted it to 3 months, possibly, or elements. We'd give it for the full year. There was an understandable cautionary approach from our business areas to not issue out maybe full year letters and confirmation or to sign contracts, because it's still indicative and they weren't sure. But I think it's trying to now, and that's we issued our letters on 7th, just the start of this week. Sorry, last Wednesday, with updated letters, and our business areas should be communicating that in due course.
Last question, Chair. What is the Minister's position on the draft budget?
Overall,
for this financial year?
Yeah, and I know the Minister wrote to the committee in January with her initial assessment, and I came up in February, and that position hasn't changed in terms of if there's not additional funding, then it's catastrophic for the department to the extent of we couldn't meet or reduce the 100 in this particular year, just to focus on 1 year, £100 million worth of pressures. And that's the point about when we've looked we're bearing down on costs. We have vacancy management. Part of our ongoing year to year, the way we've stayed within budget has been to manage vacancies. So we know there are delays. If we maybe need 3 or 4 posts filled, we might only fill 1 or 2. And each business area is trying to manage that. But Minister's very clear on if the proposed budget is still at the same, it remains the final one, then the pressures for DOJ will remain at those levels. And that's after, so whenever those pressures include estimated amounts for pay awards. So minimum of 3% built in plus 1% increment for all areas. So we've already put in those costs. The pressures we have quoted include the potential for pay awards. That will all be subject to public sector pay policy, affordability considerations, but those are in the mix already.
I mean, and the department's usually named or ranked third after health and education in terms of current shortfall in the draft budget. Would that be your perception in terms of having the greatest potential shortfall?
I would, and I mean, even that 100 million figure that I'm quoting, that excludes the emerging pressure from police of 100 million per annum for legacy to settle civil litigation claims, and the ask that we have to the executive to settle holiday pay and McLeod. And I think some of our cases are particularly the holiday pay. PSNI are the lead case, so we are further down the road of settling litigation than other areas. But yes, look, even budget-wise, health, education ourselves, the split of the original budget, we're the third highest, so it makes sense that we're pitched in there. But what I would say in terms of our pressures, when we did our 5-year plan, we only had a small amount built in for new services. The pressures we are reporting are essentially just allowing us to maintain existing services, to factor in pay awards, to factor in inflation. The likes of in 25-26, there was a 2% increase in employers' NIC. We got money for that last year, but that's not part of the baseline. So part of our inbuilt cost for this year, we're down 2%, 10-15 million pounds on employers' NIC alone. I would expect, and over the last number of years, savings naturally come out and reduced costs come out of the system. So we're not saying we can't make efficiencies. We absolutely are looking to do that. But the level that I assume and I plan for is a maximum of about 1%. So up to about £15 million. We will see some of those, we will see that money coming out. It might not be as much because of the pressures all the areas are starting the year under, but that's that's the sort of the range of where I would be thinking that's the most. If I got 15 million as a department, that would be a good start, but it's not going to touch 100 million. And in 2 years' time, it's not going to come anywhere near the 240 million. By the time we get to year 3, that's the cumulative effect of 3 years' pay awards. So if pay awards are given, so it's say maybe 40, if you have a 3% pay award and everybody goes up the scale 1 point, that's costing us probably about 45 million pounds per annum. So by the time we get to year 3, we have a pay award accumulated pressure of about 150 million pounds. So that's why it's critical. Any decision on pay awards that are taken in this first year will then follow through for the next 2 years.
Okay, Patsy?
Yeah, just I'm looking at your stabilisation pressures. Nice phrase. I enjoy that one. Could you just fill me in of stabilisation pressures of 103 million, 155 million, 242 million? How much of those stabilisation pressures, that phrase, would be cutbacks?
None. Those are the pressures that our business areas are reporting. That given the indicative draft budget they've been received, they compare that to their forecast costs for the next 3 years, and they're saying when they do that, they're 100 million, etc. short.
Sorry, maybe I should have phrased that differently. If, as a consequence of those stabilisation pressures, which I presume it means stabilising and staying as is, if you can't get that figure, the consequence of that are surely cutbacks.
And that's the point we're saying, that the reduction, the only area we could see, at least 70% of our overall budget are staff costs. The only way we could generate, say, £100 million is to reduce staff.
Yes.
And what the Minister's saying, that's not a feasible or a position that we would take forward. And that's where the position is, where I've said, and I think I stated at the last meeting as well, that at this point, in the absence of additional funding, it would be inevitable that we would overspend.
Sorry, that you would what?
It would be inevitable that we would overspend.
Right.
And that's not something I would say lightly either to the committee. That's the position we would be in.
Right. I'm getting that, and that's just if things continue, if you get meet some sort of these funds here. Which brings me on to the next question. You're probably prepped up for this anyway. The absence of a budget. What are the consequences of that then?
So at the moment, from a legal point of view, the expenditure is lawful. So the Budget Act that was passed in the previous financial year makes it lawful. Expenditure is all irregular at the moment, but that will become regularised as and when a budget is approved. In the meantime, then, we have to carry on and continue running the justice sector. And while CPEs have been issued, we feel, and it's 46 million short on resource. The reason the accounting officer in DOJ has taken the view that he's going to go with a higher figure in the proposed draft budget, because we need to give security and stability to the justice sector, that the planning that starts now, as people carry on as they are at the moment, they've all been advised they need to reduce their costs where possible. The risk if we don't do that is that services would collapse, and we end up more than likely with an underspend at the end of the year. And we've talked primarily about resource, but capital is equally difficult as well, in that if you can't pull contractors off site, if you pause a project, you potentially have penalties, and then if you start it up again in a few months' time, we're going to have capital money left at the end of the year. So it's a balance of managing the risk of we haven't got a budget, but we have a responsibility to run a justice sector.
We get all that, so if you could take you right back to the original question, if you don't get an agreed budget,
so we will have 45%. The 45% vote on account was agreed by the budget, so that gives all the departments the cash and resource 40% of the previous year's spend. If there's no budget agreed by the end of July, then up to 95% can be approved for cash and resource by the Department of Finance Permanent Secretary. But he also has to take into account, in terms of the use of cash, the AME spend but that's Amy on pensions and benefits, and sorry, not benefits, but on pensions and other Amy expenditure that actually hits in year. So it's a balancing act, but it's 95% of the previous year's budget.
Yes.
So the additional amounts that were included in the proposed draft budget wouldn't be factored into that.
Let's, now, I'm not a mathematician, so let's take you back then to the 5%. Just take the 5%. And then the requirements which you've said here about the stabilisation pressures. Could you just quantify all that for me?
What 5%
financially?
What 5% would
5%, and that's accepting these figures here of 103, 155 and 242. Would they be consequential or dependent upon the agreed budget? I presume so.
5% would be equivalent to about £75 million.
Right.
And if we got £75 million less, the 103 million pressure would become 178 million pressure.
Yes. Oh, that's what I'm getting at. Oh, that's grand.
So that would increase.
That's okay. Thanks very much.
Thank you.
Thanks, Chair.
Okay, Patsy, thank you. Richard, so what you did say there that the accounting officer is looking at current draft budget plus more?
No more than the proposed draft budget. There was
the
public consultation, so the figures in the public domain is what we have used to report pressures, and that's the figures we issued out to business areas in February time. So we've kept to that position, Chair.
Right, and is that where you're getting then your shortfall against the inescapable pressures? That's how you're coming to those totals. I think it's 1.6 million for prison service and then 12.1 million for PSNI.
Is that on the capital side of things?
Indicative draft budget allocations, 26, 27. So I'm taking that as a complete. I could be wrong. That's in table 4. Sorry.
That's just on the capital.
Oh, that's just capital.
Yes.
Right. Okay.
The approximate split. So of the 100 million, approximately for 26, 27. Just look at 1 year in isolation.
Mm-hmm.
Approximately 60 million of that would be PSNI related.
Mm-hmm.
10.5 million would be legal services, and then the remaining pressures. Next biggest ones, which you would expect, would be in prisons and courts, 3-4 million pounds, and then smaller amounts across the other areas. But of the 100 million, 60 million is for police, and we have we're waiting. Mentioned about the transformation bids. If we were successful to get those bids in and the funding, that would come off our pressures. But given that we're now also approaching July, the cost of transformation would have been forecast from the 1st of April, so we've lost a quarter already.
Yep.
And we're not starting those projects then until we get confirmation of funding.
If you're going then for the proposed draft budget as it is, and remember, if a budget's agreed, that can come down as well as go up for justice, unfortunately. So where does the contingency planning envelope come into then, to the psyche of the financial directors in each of the core department units?
It's a
bodies?
starting point. It would have been more of a focus on CPEs if we hadn't even have had the proposed draft budget shared. So if we had been sitting with no figures issued out and a CPE, then very clearly the CPE would have been the figure we would have had to work to.
Mm-hmm.
Our basis is that in order to try and maintain some sort of stability in this justice sector, if we were to implement that and say you're restricted to CPE, and hope in 3-4 whatever period of time a budget is agreed, and that as a minimum say we restate it up, we would have taken decisions potentially to reduce headcount, to stop services that wouldn't have been necessary. So it's the management of risk of, and that's what we're saying, we're not starting new services. The costs we are reporting are existing services by and large. There'll always be sort of some maybe slight tweaks and things, but that's essentially what we're reporting our pressures on. We're not putting in sort of lots of nice new things that we would want to do, and there's across the departments and the business areas will speak much better than I will about their plans. We've had to put any future development plans on hold essentially.
And that's my next question. So given everything you've said there, what shiny new things were you wanting to purchase or build that you are not now able to build because of the lack of an agreed budget?
Certainly on the capital side, we have 3 big estates across the department. We have the police estate, we have the courts estate, and we have the prisons estate, valued at overall probably in excess of £1 billion. There's ongoing. There's one element of spend which is about the ongoing minor works maintenance. Maintenance can be resource spend, but maintenance just to keep it up, health and safety, those sorts of things. I'll give you an example. The likes of prisons would maybe in the previous years been spending £14-15 million on that type of spend. Their budget might only allow them this year to do £8 million. Now, if we can get easements out from other areas, we will push that money out. But the biggest hit would be where we can plan forward for the big new developments. So the additional accommodation, emergency accommodation for prisons. Phase 1 would be, so prison numbers over at nearly sort of 2,100. Emergency accommodation of 120. There's an immediate need, or 28 million would cover that. But that's phase 1 of, that's for 120 beds or cells. To get up to 300, we're approaching about 70-80 million pounds. We have the police college. We have the various new or improved estate in prison and in police. We have McGabry developments. We have independent living units at Hydebank. We have the Royal Courts of Justice. We have Bishop Street in Derry. So those would be sort of the three. Oh, sorry. Those are a number of big ones that we can't start fully because we couldn't sign a contract to allow for those. Some of them are also at various stages of business case preparation and things like that. The main project that's in progress is Project Atlas, the new accommodation for forensics. And we're also taking forward an IT one, Themis and Courts, and Causeway, which is the overall IT system for the justice system sector. That's up for re-procurement in a couple of years' time. So there are certain ones we will take forward, but in terms of the big ticket ones, it's the prisons, courts and police estates that'll be most impacted by that.
Can I then take you on to the transformation piece? Because you had 2 bids in. But as far as I know, they have not been successful, or maybe they're in abeyance.
In abeyance. So there were 11 projects, second tranche. These were the bids that were submitted last summer. There were 11 projects that were approved by the Transformation Board. I think funding was in place for 5 or 6 of them, and some of those were the likes of health. They had match funding from the lottery, so that was big positive for them. They could offset the cost and contribute towards that. DOJ then had 2 other projects, the Ending Violence Against Women and Girls and the IT project for PSNI, that have been approved, but not from them. There's no money available from the 235 million that Treasury originally provided. Yes. The proposed draft budget includes another 135 million between resource and capital, and if that gets approved and subject to then Finance Minister going back to the Executive, we would hopefully be on that next tier, but nothing can move until an overall budget is agreed.
Which strikes me and brings me to my next point and my quick next question, that whilst we have this pot of transformational money that's meant to be used to transform and to save money effectively, or at least make efficiencies that will save money eventually. So in a perfect world where you had an adequate resource, you'd be wanting to do this stuff anyway and account for it in your budget settlement. So how far off the mark are we with regards to transformation with this draft budget, and then with regards to the contingency planning envelopes?
On those specific schemes, the likes of Ending Violence Against Women and Girls, PSNI one, we couldn't afford to do those from within existing. Those pressures would form part of the 100 million pounds. We will try and do, there are a number of sort of other reforms we've been looking at, where it's. We have 2 underway already, and that was the Transformation Fund from the previous year, and that included electronic monitoring and the speeding up justice elements. But where we've tried to do then in terms of other areas, so we have Themis underway, which is the modernisation in courts, and that's a mixture of capital and resource spend, so that's currently funded, so we're able to do the reform there, albeit some delays maybe in trying to do that. Enhanced combination orders or community orders, that's another element that there's some element of that can be done, but it can't be rolled out any further because there's not enough funding to do that, which reduce some of the costs into prisons. There'd be new adult restorative justice processes where it's trying to do things, and if there was more money in terms of, it would be almost like an invest to save item. Talking about prison reform, where we would try and do more. Then we have had the Gillen review, so a number of those implementation and reform have been happening. We've had other types of reform, like legal aid, enabling access to justice reform, things like that. So there are a number of things that are happening, and PSNI are looking at sort of AI opportunities. They're trying. Everybody's trying to do what they can within existing, but they could do more. And I think on the capital, with sustainability, or just even in terms of trying to reduce costs, more cost-effective lighting and heating and all those sorts of things, we're spending money repairing aged estates rather than investing in new ones. That gives a better estate, and it's a better facility for members of the public whenever they need to use our services. They have a better facility to come into.
Yeah. Okay. That's all the answers, all the questions, from the floor and from me. So thank you very much for your time here today. Thank you.
Thank you.
Okay, members, then we will push on. We're pressured for time. Agenda item number 7 then is SR 2026 bar 107, the Police and Criminal Evidence Northern Ireland Order 1989, Codes of Practice Order 2026. Can I refer members to page 112 to 588 of the meeting pack for the relevant papers? Can I inform members that on the 3rd of June 2026 the Department of Justice laid the statutory rule under powers conferred by the Police and Criminal Evidence Northern Ireland Order 1989 PSNI. The rule brings into force revisions to 8 existing codes of practice A to H and the introduction of 1 new code I. The rule is subject to negative resolution procedure and will come into operation on the 1st of July 2026. So can I remind members that the committee considered ASL1 and revised PACE codes at length between the 27th of February 25 and the 19th of March 2026 this year. Discussions mainly centred on options for progressing amendments to the PACE codes following the Supreme Court judgment in For Women Scotland versus Scottish Ministers, particularly with regards to Annex L to PACE Code C, which is replicated in Annex J to Code H and Annex H to Code I. Following engagement with the committee, the department agreed to publish a note alongside the PACE codes which made explicit reference to no career detriment for officers or staff members who declined to conduct a search involving a transgender person or to a transgender officer exempt from searching. At the meeting on the 19th of March 2026, the question was put that the committee was content with the proposal for a statutory rule to bring into force revisions to PACE codes of practice A to H and the introduction of new code of practice I. The committee divided 4-3 on that occasion, and the motion passed. So can I inform members that the department has confirmed that there have been no changes to the policy content since the SL1 was submitted to the committee. The note to be published with the PACE codes has been laid alongside the rule, the explanatory memorandum and the codes, and can be found at item 7.5 at page 122 of the meeting pack. So can I inform members that the rule has not yet been included in a report by the examiner of statutory rules. However, the examiner has advised at page 3 of the table pack that the rule is not required to be drawn to the special attention of the Assembly.
Chair, can I just interrupt you there?
Yep, sure.
The examiner's report is just in.
Right, okay.
And it's as you said, but it's literally just come in at 2 minutes past 4 there to say she's not drawn it to attention. So
hot off the press.
Yeah.
Okay, we're all working in real time here. So then, can I ask members if they are content with the statutory rule? If so, I'll put the question.
So just to clarify, I mean, I was looking at the Annex L, was it to?
Code C, yes.
Code C. So the wording with no career detriment is not there, but it's at page 122 in our pack. It's at the note that's been published alongside. So the PACE, right, and it will have this note will have the status of. It's from the minister, is it?
So the issue, if you've put it on the case, the PACE codes, it's an operational thing, and they don't really like putting legislative issues into operational matters and then operational matters into legislation. So that's what was causing the difficulty, although they always had said that, you know, we have no problems here, but we just can't put it into the PACE codes which are operational. So that's why then they agreed to put this adjoining note to read alongside the codes, and at that time the committee had said that they were content with that.
Yeah. And it refers to the National Police Chiefs Council?
It does
guidance.
too, yeah, which also recognises the issue too. Okay, if members are content, then I put the question that the Committee for Justice has considered Statute Rule 2026/107, the Police and Criminal Evidence Northern Ireland Order 1989, Codes of Practice Order 2026, and has no objections to the rule. Agreed?
Agreed.
Okay. Thank you, members.
Yeah, go on.
Did you get it?
No, not yet. I'm going to get it.
Agenda item number 8. Good job you're not at an auction there. You'd have
No, I
bought
know.
something
I
very
would have bought it.
expensive. Agenda item number 8 is SL1, the Justice 2011 Act, Amendment of Schedule 4, Order Northern Ireland 2026, Expansion of out-of-court disposals. So can I just say before we proceed here, the committee had requested information from the Department and the PSNI on the impact of not having assaults on police included as an OOCD. I think it was Ciara that raised that a number of weeks ago. But the responses have not yet been received.
Sorry, Chair, we do have the
Sorry.
departments in. I want to be clear. We do have the departments in, but we still don't have the PSNI one.
So we don't have the PSNI one. So we have another week on this, folks, and we should then hopefully get the PSNI one because they were due this week. So I have no problems if we want to just hold off to the last meeting in order to do this, if members are agreed.
Happy enough.
Happy enough. Ciara, you had actually raised this at that time. You were wanting to know just what the consequences would be. Are you content to wait for the week?
Yes, content, thank you.
Okay, no problems then. We can park that agenda item then. So agenda item number 9 then is Armed Forces Bill, Legislative Consent Memorandum Update, Department of Justice Written Papers. Can I refer members to pages 614 to 616 of the meeting pack for the relevant papers? Can I remind members that at the meeting on the 4th of June, members considered correspondence from the Department providing an update on the extension of certain provisions in the Armed Forces Bill to Northern Ireland. The committee agreed to ask the Department to clarify why the Minister is not seeking consent to extend the provisions of Clause 2 of the Bill, which requires certain authorities to have due regard to the Armed Forces Covenant in Northern Ireland. Can I inform members that the Department has provided a response which states that Clause 2 imposes a duty to have due regard to the principles of the Armed Forces Covenant into national authorities, and that for Northern Ireland the definition of national authority on which the duty would be placed is the First Minister and Deputy First Minister in Northern Ireland acting jointly, a Northern Ireland Minister or a Northern Ireland Department. The Department has advised that it would therefore be more appropriate for TEO to seek consent to extend these provisions on behalf of Northern Ireland departments rather than it being done by an individual departmental basis. So I understand the logic of that. So can I seek members' agreement to we maybe write to TEO to ask whether any consideration has been given to extend the provisions of Clause 2 of the Bill to Northern Ireland? Agreed? Okay. Agenda item number 10 then is Financial Services Markets Bill, Legislative Consent, Department of Justice Written Paper. I refer members to page 618 to 622 of the meeting pack for the relevant papers. Can I inform members that the Department has advised that the Justice Minister's intention to seek legislative consent for a measure contained in the Westminster Financial Services Markets Bill, which was introduced in the House of Lords on the 19th of May this year. The measure introduces an enabling power for the Treasury and UK Secretary of State to make technical amendments by way of secondary legislation to parts of the crypto recovery powers in the Proceeds of Crime Act 2002 and the Anti-Terrorism Crime and Security Act 2001 and the Terrorism Act 2000. The Department has provided a copy of the memorandum that was laid before the Assembly outlining that the Minister is not currently seeking consent at this time but intends to do so in due course. So can I ask members if they are content to note the paper, or if they require any information at this or clarification at this stage? Members content to note? Okay. Agenda item number 11 then, Personal Injury Discount Rate, Outcome of Consultation, Department of Justice Written Paper. Can I refer members to page 624 to 649 of the meeting pack for the relevant papers? Can I inform members that the Department has provided a paper on the outcome of the consultation on how inflation is taken into account by the Government Actuary when setting the personal injury discount rate. This brings back really horrendous memories of another term, another Justice Committee. 18 responses were received to the consultation, and members can find the summary of responses and next steps document at pages 631 to 649 of the meeting pack. The Department has advised that given a potential conflict of interest for the Minister, the conclusions and decisions following the consultation were taken by the Permanent Secretary, and these decisions include that an amendment to the Damages Act 1996 will be brought forward to provide more flexibility in relation to how inflation is taken into account. Secondly, that the adjustment to the inflation measure will be prescribed in the legislation, with the power for the Department to amend the measure and the adjustment via regulation. This is contrary to the majority opinion of those responding to the consultation, who favoured giving the rate settler the ability to adjust the index rather than prescribing the adjustment. The Department's rationale for its approach is set out in paragraphs 20 of page 629 of the meeting pack. And then thirdly, the Department has also determined that the CPI should be the preferred inflation index by which to prescribe the inflation measures. So can I inform members that the Department has also advised that as there is currently no available vehicle within the Department's current legislative programme, the intention is to bring forward amendments of the 1996 Act in the next mandate, subject to the views of an incoming Minister of Justice and then of course the Executive. So can I ask members if they are content to note the paper or if they require any further information or clarification at this stage? I can tell you now, having the scars and the memory on this issue, if it's not going to be dealt with until next term, we'll just let it be there and note this paper.
Very complicated.
I will also say that there has been changes even to the Department's position on this stuff. So I'm loath to get into this debate again because it would pull your hair out. Okay, agenda item number 12. Police Pensions Amendment Regulations 2026 CPA Consultation, Department of Justice written paper. Can I refer members to pages 651 to 673 of the meeting pack for the relevant papers? Can I inform members that the Department has advised that the commencement of a 12-week consultation on the Police Pensions Amendment Regulations Northern Ireland 2026, which will run from the 6th of July to the 2nd of October 2026. The purpose of the regulations being consulted on is to amend the Police Pension Regulations Northern Ireland 2015, so that's the 2015 regulations, to address the interaction between the Consumer Price Index, the CPI, and the annual allowance, which is AA, within the 2015 police pension scheme by moving the effective scheme re-evaluation date from the 1st of April to the 6th of April. In addition, they will also remove the end date for current member contribution rates, which are presently set to expire on the 31st of March 2027, in line with the scheme valuation requirements. The Department has advised that, subject to the outcome of the consultation exercise and ministerial agreement, the proposal for the regulations will be brought to the committee in due course. So, can I ask members if they're content to note the paper or if they require any further information or clarification at this stage? Happy to content to note, sorry. Agenda item number 13 is legal aid remuneration consultation, Department of Justice written paper. Can I refer members to page 675 to 748 of the meeting pack, and then also pages 5 to 8 of the table pack. Can I inform members that the Department has provided a paper on the proposals to implement further changes to legal aid remuneration following the accelerated review of criminal legal aid, as well as the targeted consultation on these proposals. This follows the Minister's acceptance of the recommendations in the recent accelerated review. Given that an enhanced evidence base is required to support additional exceptional preparation rates, it is proposed that the recommendations are implemented in 2 phases. Phase 1 includes a recommendation for a general uplift of specified fees for criminal legal aid of 8.66%. It's further to the 16% uplift in December 2024. Which will take effect from the 3rd of June 2026 for solicitors and the date on which the withdrawal of services in the Crown Court ceases for counsel. The same uplift will apply to civil and family legal aid remuneration. Additionally, it is proposed that the 26.05% uplift for Crown Court exceptional preparation rates, which were out of scope of the previous 16%, will then take effect from the 3rd of June 2026 for solicitors and for counsel on the date they return to work in the Crown Court. And then phase 2, which will include the recommendation linked to exceptional preparation reform, includes additional fee changes to exceptional preparation hourly rates, consultations, review of audio-visual material and reading, including disclosure, and these will be progressed in the next Assembly mandate. So the Department also proposes to incorporate some further amendments relating to exceptional preparation, prospectivity, the interim payment of disbursements and the County Court Scales fees. So can I inform members that the 8-week targeted consultation will run from the 26th of June 2026. So can I ask members if they're content to note the paper and consider further when the outcome of the consultation is available, or if they require any further information or clarification at this stage? Are members content to note?
Content.
Okay. Agenda item number 14 then is the Department of Justice update on progress against the Department's 25-26 business plan. A written paper from the Department of Justice. Can I refer members to page 750 to 762 of the meeting pack? Can I inform members that the Department has provided a summary of progress against the Department's 25-26 business plan for the Committee's consideration? The position will be reflected in the Department's annual report and accounts for 25-26, which are due to be laid in the Assembly in advance of the summer recess. The summary shows that it is not possible to advance one action due to lack of staff resources, while 35 actions were achieved. It also provides details of work ongoing in respect of 14 actions which were partially achieved. So can I ask members if they're content to note the paper, or if they require any further information or clarification at this stage? Happy to content to note? Okay. Agenda item number 15 is the Independent Review of Criminal Record Certificates Annual Report. Can I refer members to pages 764 to 777 of the meeting pack, which contains a briefing paper from the Department of Justice and a copy of the Annual Report 25-26 of the Independent Reviewer of Criminal Record Certificates. Can I inform members that the latest report addresses several aspects of the Independent Reviewer's functions in relation to Access NI, including demand for review of information disclosed, auto referrals for review, appeals and then youth cautions. The Department has also advised that the IR has made no new recommendations in her report, but has acknowledged the work of the Department in progressing earlier recommendation and taking forward work to update and reform the Access NI list of specified offences. So can I ask members then if they are content to note the paper, if they require any further information or clarification? Content to note? Agenda item number 16 then is correspondence. Can I inform members that there is a correspondence memo on 10 items of correspondence, pages 779 to 867 of the meeting pack, and then one item of correspondence beginning at page 10 of the table pack. So can I advise members at 16.12 that the only item of correspondence that I wish to draw their attention to is that item in the table pack. It is a paper from the Northern Ireland Human Rights Commission providing advice on the amendments tabled to the Justice Bill to raise the minimum age of criminal responsibility. The Commission has asked that the paper be circulated to committee members to assist consideration of these amendments. Patsy, you want to come in on this?
Well, not particularly in this, just in another item of correspondence, Paul.
Okay, I'll come to you in a wee minute. So I'll deal with this. And so can I ask members if they're content to note the paper, or if they require any further information or clarification at this time? Content to note?
Okay.
So can I then seek agreement to publish the paper on the committee's webpage along with the other documents received following completion of the committee stage of that bill, which has already been published? Okay. Then Patsy, do you want to come in now?
It was just the one about 16.8 there. The response, PSNI response about the amendments on firearms licensing fees, to suggest that that be shared with BASC, given that there was a joint presentation that day.
Okay. Are members content with that? And the clerk has no problem with that? Okay, that's fine. Thanks, Patsy.
Okay, thank you.
Can I ask, does any other members want to raise any correspondence, or are they content to note the other items? Content to note. Okay, agenda item number 17 then. Forward Work Programme. Can I refer members to the latest draft of the committee's work programme, which is at pages 869 to 879 of the meeting pack. And this is to note unless members have any comments they wish to make. Just although that's quite scary, what we're going into in September, so just make the most of your absence here. I know you'll be working in your constituencies, which will be a nice break and change from the norm of plenary and committee work. Okay, but it's all ahead of us, folks. Agenda item number 18 then is chairperson's business. Can I advise members that I have no chairperson's business? Agenda item number 19 then is any other business. Can I ask members if they have any other business they want to raise? If not, then agenda item number 20 is date, time and place of the next meeting. Can I advise members that the next meeting will take place on Thursday the 2nd of July 2026 at 2 p.m. in room 30 Parliament Buildings. I adjourn the meeting.